Yes, this lecture is on ethics, business ethics, chapter 5, and it starts off talking about the profit motive. It used to be that a lot of people would teach, and still teach today, a lot of people still teach and believe that the primary purpose of a business is to make a profit for the owners. However, the more enlightened view now is that there's a sort of triple-double bottom line. The triple bottom line is, first off, the owner's profit is still an important thing. The owner's putting up the money, and he's got to expect to be making money in order to justify his risking his money. And so it's important that the owner get a profit. He's a very important stakeholder. The second category of interest, the second of the triple bottom line, is the impact on other stakeholders, which would include things like the employees, the consumers who buy the product, the community in which the firm operates, the people who supply the ingredients, the parts that go into the product, anybody who's connected in any way to the firm is in some sense a stakeholder, and therefore has an interest in what happens with the firm. And if there are decisions made it's going to impact him, oftentimes he would hope that his long service to the company would be perhaps rewarded with some consideration, and that he would not necessarily just be discarded because of the exigency of doing so. But obviously this is oftentimes what does happen, and part of the concern is that this is maybe something that undermines morale of companies throughout the country. People are worried about what will happen to them if their input is going to be diminished or discarded. And the third triple of the bottom line is actually more of an environmental impact. It's the impact on the community, which includes the environment, amongst other things. These three considerations blend into the concept of corporate citizenship. A firm is expected to do more nowadays than merely earn a profit for the owners and merely obey the laws. They're expected to earn a profit and to obey the laws, but there's usually an expectation that the firm will do something more for the community, do something more for the people it employs, do something more for the consumers who it depends upon for its products. And there are reasons why a firm is wise to acknowledge these inputs, acknowledge these concerns, acknowledge these interests. Image is everything. Firms and the people who manage them are now aware of the importance of branding. Disgruntled workers, disappointed consumers, and enraged citizens of a community, a nation, enraged citizens of the world, they all have access to the internet and can impact the firm. Picketing and boycotts are easier to organize nowadays with smartphones. So it's not only your employees who might be going on strike and picketing your firm, it's also maybe your consumers. So for instance, I talked to you earlier when we talked about discrimination, and we talked about Revlon and the threat that feminists made to boycott Revlon, a firm that sold pretty much to women or people who were somehow going to be buying for women, husbands and boyfriends. So this firm would be very much impacted by a boycott of women, and women urging people not to buy the products of that firm would have a great impact. And the reason they were threatening a boycott is their perception that the firm had discriminated against women in the executive suite, the so-called glass ceiling. And they thought that since it was a firm owned by a woman, that it should be more, and since it was a firm that was selling to women, it should be more concerned with promoting women into executive ranks. And it had no women executives at all, and had not hired anybody. Oh, well, it did have one executive who was a woman, that happened to be the owner of the firm, but that was it. So you could say that the owner of the firm, a woman, was discriminating against women, according to the feminists, and they were going to boycott her firm. And Enron, when it caught wind of this, and the feminists made no secret of it, they actually intended, I think, for her to take notice. When she got notice of it, she immediately caused the firm to become very active in recruiting women and finding women to promote into executive ranks. So, you know, it went up and down through the firm and found smart women who they thought could learn to be executives, and promoted them, and then taught them what they needed to learn, and became a firm which had substantial women executives pretty much overnight. And in doing so, of course, they were invoking affirmative action. In other words, women who didn't appear to have the qualifications, didn't have the educational degrees, didn't have maybe the years of experience that would have gone with this particular title, might be promoted into a job because they were viewed as being competent to do it, and the firm felt a necessity to get women like that. I don't think the firm was promoting any women who it didn't think were up to doing the job. I think firms under affirmative action do actually want people who will be able to do the job competently and maybe exemplarily. But, you know, obviously the rules are different with discrimination. And, you know, nowadays, of course, discrimination has perhaps been substantially weakened by Supreme Court decisions. Anyway, that was what happened then. But it's still, to this day, I think, boycotts would be very effective if women used them against firms to cause firms to think about hiring more women. If they perceive that there is indeed a lot of discrimination against women and that these firms can do something about it, I think the threat of boycott would perhaps with many firms cause them to rethink their agenda. You know, so this is a marketing force, isn't it? Could a firm have done this before the 1964 Civil Rights Act, under which affirmative actions are you know, justified? Of course they could have. You know, they could have recognized that, well, we've got customers out there and they're very upset and they want us to hire women, maybe we should hire some women. So a firm has to take notice of these things, and it's going to go into the bottom line. And so the triple bottom line has a deeper meaning than what might appear on the surface. It's not just that it's a good thing for the firm to take notice of these groups, of these other you know, these other groups other than the owner that actually have some sort of entitlement or feel they have some sort of entitlement from the firm. And so these groups are important to the firm, and so it must acknowledge that. So image is everything. The firms and the people who manage them are now aware of the importance of branding, and you see that amongst leaders in business. You see that in the leadership of the United States. The President of the United States is a person who devoted a lot to his branding. He considers his name to be a brand name, and you know, he considers branding to be very important, and he's very good at marketing. And so he's right. Branding is something that a firm has to acknowledge and is of overwhelming importance. You've got to sell your product, otherwise you don't have anything in the game, right? That's the whole name in some sense. Not the whole game, but it's certainly a big part of the game, is being able to sell your product, and in some cases to be able to sell yourself and to establish your brand. Disgruntled workers, disappointed consumers, and the enraged citizens of the community. This would be the women of the community, right, that we talked about, and also the nation and of the world. They all have access to the internet, so they can quickly organize a boycott. This is also more easily done because of the smartphone. Picketing and boycotts are easier to organize with smartphones now. You know, you can have people showing up, and you can arrange and organize things much more quickly if you know what you're doing with your smartphones, and people will respond to that. Managers cannot ignore the negative impact of a bad reputation. This leads at a minimum to a concern that with public perceptions of the morality and social values of the firm. So the public, you know, all these stakeholders who are part of the public can influence the management's decision. So we are oftentimes influenced by other people in making decisions, and and we're influenced by groups, and so groups can influence our decision making, and so we have to be aware of what these groups think, and we have to respond to it. And it's probably better to respond to it before there's a threat of a boycott. You'll probably be given more points if you're seen as doing it because you think it's the right thing to do. And so you find this in a lot of firms that are very conscious of their branding and therefore try to create an image of a firm that is very sensitive to the needs of others and doing the right thing, not only for itself and its owners and for its stakeholders, but also for the world. I think you find this to be a very common theme of corporations now, and successful corporations do that. And so it's important that we notice that this is really what's happening. It's not really a matter of firms being able to go back to the old ideal of, oh well, all we have to do is generate a profit for the owners, and then we're going to do fine. So it leads to a minimum with a concern with public perceptions of the morality and the social value of the firm. That's at a minimum. It's probably much more deep than that. Law and ethics. Moral. Compliance with the law is a moral minimum, earns an inadequate rating grade in corporate citizenship. Businesses who want to have good branding need moral initiatives and authenticity. They need to be doing things for people. They need to be seen as proactive. They need to be seen as a force for good in this world. Otherwise, I think they're just hurting themselves if they're not seen that way. Now, that means there's a possibility of them manipulating that image and appearing to be good, when they really aren't. But then again, it is at least a step in the right direction that they are conscious of the fact that they need to at least appear that way. And it's even better if they think the easiest way to actually appear that way is to actually be that way. And I think many of them have reached that conclusion. So Google, upon adopting a corporate ethical code, went beyond the standards of non-discrimination and took a stand supporting non-discrimination consistent with the LGBTQ agenda at that time. And it implemented it, improving its brand image with younger users. I think younger users were largely affected by that and therefore thought much better of Google because it did that. And other firms that follow that example, I think, get the benefits of that. The younger consumer is going to be the longer consumer. And a firm that is able to appeal to the young consumers can look forward to success in the future. Whereas if you ignore the younger consumer, it's not going to be good for your firm in the long run. Now, you might immediately make some short-term profits, but do I want to invest in your firm if I see your profits maybe diminishing over time? That although you're riding high now, you're maybe not going to be quite as fantastical in the future? I guess not. I probably wouldn't want to do that. So when I was in school, we had lots of talk about the importance of attracting investors to your firm. That one measure of success is not only whether your product is selling, not only whether or not you've got a good brand. We didn't even talk about brands back then, but we did talk about attracting capital. Okay. And so Google did that. Now, you can take the opposite of Google. Enron adopted a professionally prepared company code, which its board on numerous occasions subsequently made exceptions for their CFO, Andy Fastow, who then actively subverted not only that code, but the ethical values of that code, the ethical values of the American Institute of Certified Public Accountants, and financial ethical codes, misleading investors and precipitating the Enron's financial collapse. So it did no good for Enron to project a false projection of a good image, a projection of a responsible firm, an ethical firm, was not enough to save Enron from its eventual fall. So obviously branding is important, but you need to also pay attention that you're actually following through with the branding, that you're not only projecting a good image, you're not only projecting that you're profitable and successful and are up to date and new, but you actually are. And sometimes I think with Enron it was a case where there was a group think that they thought they were doing the right things, but they weren't. They were misleading themselves. They were just simply denying the truth. And they had adopted policies that caused people to mislead them, that they were rewarding people who reported making lots of money, and they didn't look very closely at people reporting making lots of money. They weren't just really very good at determining whether or not people were actually producing the kind of results that they were supposed to be producing. So Andy Fastow was always given fast ratings, good ratings, because he continually, by cooking the books, continually allowed them to show profits, which increased their number of shareholders who were investing in the firm, and that was what they thought was what they needed. And it just turned out not to be enough to have that impression when they actually were losing money in a lot of the markets that they were in, that they supposedly had been making money, and eventually this was going to come out. It's like sweeping dirt under a rug, right? You can only do it so long, and then you're going to pay the price. And so they weren't so smart after all. You should read the book, The Smartest Guys in the Room. It's really a good book to read, to see how people can fool themselves by denial, and you know, how they want to believe they're successful when they ought to know better. And you know, so one needs to follow good business practices. Okay, now I want to make a comparisons. Let's make a comparison between the law, and we're talking now, I'm going to be talking about a law that's very formalistic and very legal, a law that's going to follow the letter of the law, so to speak. And it's not going to look to the consequences of the law. It's not going to look at anything more than what does the letter mean to the citizens who elected those legislators who passed the law. I'm talking about that kind of law, a very rational, very principled kind of law. Okay, so, and then I'm going to talk about ethics, and we'll compare these two kinds of ways of thinking about the law. Law values cold rationality. What does the statute say? How should that be a statute how should that logically be interpreted by a rational human being as to what it means? And perhaps there'll be some acknowledgement that we have to follow statutes and the Constitution. The Constitution itself would be a very limited kind of thing that limits government and basically prevents the government from intervening when corporations want to do things that are not necessarily good for the country. And when corporations simply want to focus on making profits, the Constitution is not necessarily going to interfere with that if read from a very formalistic, letter of the law kind of way. Okay, so the values are therefore cold and rational under this view of the law. Ethics values warm rationality. By what do I mean by that? What's warm rationality? I think that there's a difference between cold rationality and warm rationality. Warm rationality takes into account that people are not just simply cold calculating machines. They're not computers. They're not robots. They're people with emotions, and therefore make decisions based not only upon cold rationality, but upon their own feelings of things. So a person might think that it might be a good idea to invest, but he may not feel comfortable investing, and he may be scared to invest. And maybe that intuition is actually more valuable than the cold rationalization, as we saw in just the more recent past in regard to the virus that has so devastated the nation and the economy. And the economy is being devastated because the decision makers just didn't see it coming. They didn't see it coming because they didn't realize the impact that people would have, that the virus would have. People, yes, there are people outside who are demonstrating to go back to work and wanting to go back to work, but a lot of people are saying they don't individually want to go out to work, you know. And so I guess people who are desperate, who depend upon a job, will want to go back out to work. But people who are not desperate are basically want to get control of this virus and do what the scientists say is going to lead to success. At least that's what I'm counting on. That's not coldly rational, that's warmly rational, because it's taking into account people's feelings and not just simply the fact that some people are going to be financially benefited by going back to work. And so I think that warm rationality is something that you show in terms of bringing ethics into your decision-making process. The law strives to be objective. We strive to have our laws interpreted objectively. What do they mean? What do these words mean? And that's what we're going to do then, right? So that would be objective. Whereas the ethical concerns oftentimes are striving to be caring. We're striving to do that which is best for people, which is different than being objective. Not necessarily subjective. Maybe to a certain degree it can be objective, but it's not necessarily just strictly objective. It's also concerned with people's feelings about it and acknowledges that people are not actually just calculators that are going to do what might seem rational on a cold calculation. Now also we'll take a look now at the law. Often is delusional in regard to its universality. That basically a lot of the people, starting with our founding fathers and their belief in the natural law, believed that their law was universal. Gradually people became aware that the law was different in different countries, that different people had different conceptions of the law, and therefore it wasn't universal. But I think a lot of people still maintain that, well, it should be, that there is having an objective universal principle of law is an important keystone to the Western world's success. I think that's a delusion. I think the Western world's success was due to a number of factors, one of which might have been its rationality, but also might have been other factors that were affecting its success. Okay, the ethic, on the other hand, acknowledges people and their situations are often unique. So you can't say that things are universal. People exist with different kinds of challenges in their environment. Things are different, say, in Africa. Things are different in Asia. Things are different in Australia. Things are different in Europe than they are in the United States. And so the response for these different countries will be different, predictably so. And so you have to acknowledge that people in their situations will make different decisions depending upon what challenges they find them facing and what they think is going to be best for them. And it's not entirely going to be a rational process that some economists might applying the rationality of the economics that I was taught. Okay, fourth item. Also, the law is supposed to be consistent. And I'm saying it's consistent sometimes to a fault. Sometimes we're following a precedent when maybe we should abandon that precedent. And of course, some people want to abandon one precedent and not other precedents. And you find judges are not actually consistent. Some judges who say they are all for upholding precedent don't actually uphold precedents that they don't like. And other judges who basically are seen as being persons who are throwing out some precedents will be upholding other precedents. So precedents are usually upheld not on the basis of some rational decision, not on the basis that precedents in themselves are actually always good, but on the basis of how individual judges actually see them. And depending upon who appointed the judges, what sort of tribe they came from. Did they come from a liberal tribe, or did they come from a more conservative tribe? Did they come from an original intent tribe, or did they come from a living constitution tribe? That may make a large difference in how they decide that. So consistency, the court tries to be consistent, and sometimes it does so to a fault, and sometimes it should think about that. I think one of the more famous judges at one time said that he was accused of not being consistent in some of his decisions. He says, well, consistency is a hobgoblin of little minds. And he was referring, that was actually a very famous judge. And he was referring to other judges. Anyway, ethics more readily recognizes the need for change, I think. When we talk about ethics, we don't feel compelled. I mean, there wasn't this belief, I don't think there was a belief in the natural law, and that natural law was something that was permanent, universal, unchanging. And I don't think that held over with ethics. Ethics has been viewed and changed over the years. And so, whether you're talking about Kantian duty ethics, who said that people need to be bold in their thinking, and advocated people throwing out old ideals from the past, or whether you talk about Mills and utilitarianism, in which he was saying that we need to consider the impact of what our decisions are. And I think the book, by the way, is actually very bad in terms of presenting a very wrong interpretation of utilitarianism. It's not all about the greatest good for the great number. John Stuart Mill explicitly denied that when confronted with an example of people saying, well, wouldn't it be good to have a slave state if, in fact, on average, people were happier in the slave state, even though there were very miserable slaves? And he said, no, we have to consider the individuals as well as simply the persons. And doing something that's wrong for individuals is just simply wrong. And he was a strong believer in the rights of men and was a strong supporter of civil rights, and worked tirelessly to get rights for women and for blacks and for oppressed people, for poor people. He was not actually a cold-hearted calculator of pleasures and discomforts. Okay, so more readily recognized ethics, I think, actually more readily recognizes the need for change than the law that we're talking about, where you're just looking at the principles and you have a very logical system. Justice Holmes said that the law has not ever been about logic, but has always been about experience. Judges base their decisions upon their experience. Whether they're conservative or whether they're liberal, it's all the same. Both of them will vote in terms of what they think their experience justifies. Okay, so the fifth thing that I talk about in terms of the comparison of these two is principles. Yes, the law is principle, and no, it does depend upon the judge's experience nonetheless. Also, how about ethics? Is it principle? Yes, it is. There are principles usually behind ethical statements, but it also depends upon the judge's jurisprudence. So you have the experience in law, which can affect a judge's leaning, and if he said experience as a conservative, and he believes that that's the correct way to decide cases, he'll probably lean that way. And if you have a judge who's been more brought up at sorts of liberal living constitution, then he's likely to go more for that kind of view. Excuse me a second. Okay. Comparison of adaptability. So we talked about Tommy and Stan in an earlier case involving these two people who had contracted, and I thought they had a partnership. And so the decision in that case, I think, was a more pragmatic decision than it was one of rigid rules. The judge, I think, I was able to persuade the judge not to apply the letter of the law. By all rights, he could have said, well, the letter of the law is that if you're going to present a writing and claim there's a contract, you have to prove it by a writing. I never had the real writing to prove that statement. I think the writing I had was inadequate, but I was not the one to point that out. That was for my opponent, or perhaps the judge might have. I think the judge saw it was inadequate. He looked at my opponent with somewhat awe, as if he thought he would say something, but when I gave the writing to my opponent, he kind of looked at it, and I don't think he really understood what he was looking at the way I understood it, and he didn't object, and so he kind of accepted it, and the judge just went along with it. But the judge could have pulled the rug out. But then again, a judge probably shouldn't interfere with the progression of the case each side has its advocates. Anyway, the judge, applying the letter of the law, would have maybe looked at the formal logical application of the rules designed to promote universality and consistency and said, well, you haven't met the requirements. A more realistic review of the presented facts, which I had given to the judge, were designed to shape a caring solution to this particular problem. The particular problem involved something that was subjective of a kind of fraud being committed. I won't say that the other litigant actually intended a fraud. I think he was led by his lawyer to think that everything he's doing was right. And I'm not saying that the lawyer thought of it in terms of fraud either. He simply thought of it as applying the law as it is written. But it was a kind of fraud, and that the outcome was going to be wrong. My client had contributed substantial money and worked for 6 months in the business as a partner, and they had represented themselves as a partner. And I knew that they had agreed to be a partnership, although I could not testify to that in court, because you cannot testify as to what was said during negotiations. Okay, so rigid rules of the law requires a majority of state judges to strictly dismiss a case in absence of a writing meeting the rule of law requirements, invoking the traditional and orthodox principles of this law. That's what it requires, and that's what the majority of states would have done. I, however, was fortunate to have a claim that there was an exception in the state of Ohio, which was based largely on a trial court, which is not a very good precedent. And so this would allow a minority of states judges to hear, my argument from a pragmatic standpoint allows the minority of state judges to hear exceptional facts present in this case. So I was talking about this case's facts to justify the judge bypassing the strict application of the letter of the law and dismiss the case in absence of a writing meeting the rule orthodox. So I was doing something extraordinary in making that argument. And it was unusual. It was exhilarating when I won, but there was a possibility I would not have won. So the result was that the informed judge was able to make a fair and equitable resolution of the case. Constitutional rights. Employers have abused, and we talk about ethics, and one of the things is right now with the the internet, employers have sometimes abused ethical consideration in regard to things that are said on the internet. Before they hire people nowadays, of course, they look to see what the person has published oftentimes. So that one of the things they want to look at is not only the resume and the information submitted, not only the school records, but also they'll want to look up what this person may have done in the social media of the day, Facebook, Twitter, what have you, all those various things. It's under something called RV, I guess, or VR, yeah. And that's a new one to me. I've heard of the others, but I hadn't heard of this one. Anyway, so I guess that's virtual reality somehow. And so there's some sort of like ongoing thing with virtual reality where people are presenting themselves to the public using that. And so they'll want to see how people are presenting themselves. And these companies oftentimes have rules on how you can present yourself, what you can say and what you cannot say. And if you violate these rules, you can be therefore fired. And so, it brings up the question of whether or not they're violating people's rights. Are they violating people's right to invading their privacy in terms of being able to access these things or requiring them to maybe disclose to them things like this? In some cases, a firm may have a rule that relates to a person's choice. So Chick-fil-A may have a rule, I believe it has a rule that says its employees will not have an abortion because of its deep-seated belief of its owners and people who run the place that abortions are a terrible thing and should never be admitted, okay? But the view of the Supreme Court currently is that this is actually a constitutional right, and so basically they would be invading the right to privacy by saying to people like that they cannot have an abortion. The second kind of thing is suppression of free speech. So you have that happening with Costco and the NLRB case, they talked about on page 93 of the book, social media case. You know, where somebody's maybe going to be fired for something that they said about a fellow worker or a criticism they made of a manager. Is this suppression of free speech? And I believe that's probably going to be held true to be a suppression of free speech. Employers doing that people ought to be able to criticize public actors at least. Anyway, there's also issues about violating privileged immunity citizenships, keeping voters working to prevent them from voting, things like that. So there are these issues that are coming up. Ethical codes. There are these company codes used to suppress speech which either undermines authority or impairs the image desired by the firm, invoked to discipline or discharge employees. You know, so this is what you see with Costco and other firms. I remember a case involving a airline stewardess who actually showed herself on the airline on one of the airplanes dressed in her uniform, and she had pictures posted on there, some of which were thought to be a little bit sexually oriented. There wasn't nudity. I don't think there was any acting out of anything that would have been seen as aggressive. If it was porn, it was soft porn. You know, maybe she was smiling at people. Maybe she had her button, her top button loose. You know, perhaps there might have been some décolletage, but nothing really quite so scandalous. Nonetheless, they fired her because she had violated the rule that she was not supposed to be seen on the internet wearing her uniform in any case, and for that reason alone, that rigid kind of rule, they enforced that and they fired her for that. And so you can see that these corporations are more and more powerful in terms of our lives than, say, the government. I'm not worried about a tyrannical government. I'm worried about a tyrannical corporation, a tyrannical employer. I'm not worried about being suppressed or having my speech restricted by my government. I'm more worried about my potentially an employer that I might have. Okay. And okay, so that's company codes that are used to suppress speech which either undermines the authority of the firm or impairs its image. So image is important to firms, and they know that. So the image desired by the firm could be impaired by something the employee says. So he's got to be careful about what he's saying. And it's probably best if he not say anything at all if he's concerned about losing his job. Okay, now the second thing we have to talk about here in terms of ethical codes, there are also industry or professional codes. These are used to enhance or protect the public respect, regard, or reputation of those identified as members of an industry or profession. So I'm a lawyer. I have to be aware that I don't want to project an image of lawyers, myself or other lawyers, as being disreputable, because that would be damaging to the profession. And so I have to be aware of the appearance of impropriety. I don't want to appear to be doing something wrong. And so that's true of a lot of people in different professions. If you're an accountant, you have an ethical code dictated by your profession. If you're a doctor, again, you have an ethical code. A dentist, have an ethical code. Nurses, all these codes basically can stop you from practicing your profession if you violate their rules. And so you have to be aware of what those rules are and how you're to behave under those rules, what you should do and what you should not do. And the whole point is that the image of the profession needs to be protected so people don't lose respect for the profession. And so that's going to a lot of kinds of industries even now. Examples, I'll give you other examples. Baseball. Baseball has long had a rule that a player who's caught gambling, not necessarily betting on or against his firm, his ball team, just simply gambling, will be discharged from baseball. And we saw this happen with one of the more famous ball players of all time, Pete Rose, who was dismissed from baseball and the Hall of Fame because he had been gambling. And that was all they ever proved against him. It never was shown that he had ever thrown a game or bet against his team or bet on his team, that his betting was perhaps on other teams and had nothing to do with his management of the club. But nonetheless, it's a strict rule with them. They don't allow that. And there are strict rules in all professions. Doctors have to be very conscious about how they're treating patients who are under anesthesia. So doctors have been convicted for doing inappropriate things while people are under anesthesia. Nurses have to be aware that they cannot accept extraordinary, expensive gifts from people that they're taking care of that are unusual. That person dies and they leave them the farm. That's an unusual gift that can be challenged as an undue influence case. Accountants have to keep their clients' secrets, so they know lots of secrets about their science financing, and they have to be aware that those secrets have to be kept secret. And this happens in banking too. I remember as a student working at a savings and loan and knowing people who had missed their payment on their mortgage and seeing them later that same month and not being able to say anything to them about, well, you better make your payment, because it would reveal that I knew their payment. And how did I know it? I knew it because I was working at a bank. They didn't have to tell me that I should be revealing this. I realized myself that this is something I should never disclose. And hopefully they were all okay. Okay. Anyway, industry of professional codes used to enhance or protect the public respect, regard, or reputation of those identifiable members of the code. Baseball we talked about. Lawyers we talked about. The appearance of impropriety. Home care nurses, yes. Accountants we talked about. Okay, so these are all people who have to live with these codes. Business Roundtable Institute for Ethics. There's an extraordinary statement made by Dean Kramer, who was running the Business Roundtable at that time. And he said, evidence suggests that being ethical, doing the right thing, pays. And I believe that. I believe that it does myself. But he talks about evidence. Now, I don't know that he presented the evidence, but maybe he felt there was evidence, or from what he knew. But I don't see where that's actually, so I don't know where that actually is, if there was such evidence. Anyway, moral and ethical and religious, I think there are people who've written articles and papers on it, but I'm not going into reading all that anyway. So moral and ethical and religious principles can be a unifying force, and beliefs about lying, stealing, and charity are often widely shared. So there are certain moral and religious beliefs that are widely shared, I think. I think everybody agrees that lying is wrong. However, everybody lies all the time. And I think people make distinctions in terms of certain lies, and certain lies will maybe be called white lies, or they'll even deny that those are lies, because nobody's being hurt by this misrepresentation. So you tell somebody that you enjoyed going to their house for a game of Parcheesi, but you hate Parcheesi and you hated going there and you don't want to go again. Why do you tell them that? Because you don't want to hurt their feelings. It's not that you expect to gain anything by telling them that. It's simply not that they're going to suffer because you told them that. They might suffer more if you told them the truth. And so you lied to them for that reason. That's a white lie, isn't it? People do those kinds of lies all the time. So some moralists will make a distinction between those kind of lies, and others will say, no, you should never lie, regardless. Okay, moral and ethical and religious principles can be a unifying force, and therefore that they can bring a workforce together, provided they're shared and reinforced by members of the group. However, some ethical issues are controversial. Acting on them can lead to negative publicity and even protests or boycotts, or even people maybe won't go to your firm. So I know people who will not go to Chick-fil-A because they view it as being reprehensible because of its views, its stance on certain religious issues, which are important to the owners. And I guess if the owners want to suffer from that, that's fine. But you as an employee needs to know what your firm is actually into, if that's the case. And you might want to avoid it. And firms have sometimes had to back off of positions. So you've found owners of firms who made a misstep and said something that they probably regret saying, and later, they have taken steps maybe to correct the impression that perhaps they were biased or negative and discriminating against a certain group. You'll find that that's a very common kind of feature in today's world, where somebody has made a misstep, and either intentionally or not, they need to actually do something to correct the misimpression, perhaps, that they are in fact discriminating or of a discriminatory mind or racist or whatever. However, some ethical issues are controversial. Acting on them can lead to negative publicity and even protests or boycotts. So obviously, it would have been a good idea for them not to get that out, if Revlon, in terms of that. So anyway, so we're going to talk now about duty-based ethics. So we talked, I believe we haven't talked about, I'm going to talk about, again, duty ethics. But we'll talk about it from the point of view of Kant. But here, right now, I'm going to briefly talk about some other issues in terms of duty ethics. Of course, religious ethical systems tend to be very duty-oriented. The Ten Commandments. Ten Commandments are the rule. It's an ethical system followed by many who are Christian, followed by many who are Jewish, who have the same code in their Old Testament. And they have the Ten Commandments. That's where it comes from, is the Old Testament. And the Muslims follow the book too. So they always recognize the book as a holy book. They recognize the Jewish prophets and Jesus as a prophet and men who spoke the truth and therefore took seriously the things that they say. These systems tend to be often uncompromising, which is why you see such controversy in things like abortion. If you believe that killing is wrong under the Bible and that abortion is killing, then you're going to be uncompromising in your view and not allow any kind of abortion for any reason, not to save the life of the mother, not because this child was raped by somebody, by her father perhaps, and it was the child that's going to be born is going to be the product of incest, not because of the life of the mother. None of these things are going to stand in your way of your literal interpretation of that commandment, if that's the way you believe. So religious ethical systems are commandments. They are definitely a strong form of duty ethics, uncompromising in many ways. However, of course, some people in the various religions will interpret these things in a much less strict way. They're not maybe necessarily going to interpret them in terms of the words that have been translated from one language to another over a period of years, and whether those words that were said over 2,000 years ago are actually meaning the same thing today as they would have then, or whether or not the people who said them would change them. These words are oftentimes thought to be the words of God, and the translators were thought to be inspired by God, therefore they're taken very literally. So that's religious ethical systems. The principle of rights. The principle of rights is a belief that persons have inalienable rights. So this is kind of also a system of duty. And if a person has a right, it's our duty. If you have a right, it's my duty to recognize your right and not intervene with your rights. And your right would maybe trump over my actions that I might want to restrict your saying something. But since you have a right to free speech, I can't do that under our Constitution. And so that's the principle of rights. So there's a belief now, most people believe that persons have inalienable fundamental rights, right? Jefferson called them inalienable. Nowadays we often talk about them as being fundamental. But the point is the same, is that these are things that have been part of nature, almost part of the natural law, that these are inalienable rights that came from God. Or if you could take the view that for certain of the framers, they might have meant it in terms of, well, these are reasonable rights that should be there, a person of reason, following more or less the Roman conception of rights, which was one of people as human beings, because they're humans, have a right to certain things because of their humanity, which is a kind of a reasonable way of arriving at the concept of a right, that this is something that naturally attaches to a sentient human being. It doesn't attach necessarily to an alligator or a duck who is not sentient, or even a dog who perhaps has some consciousness and some emotions. Some people even say souls, but we generally don't think of them as having rights under our system. And so now some people do, and some people think the earth have a right too. So that's, I mean, there are always some people who have different views, but I think most people would say that fundamental rights are restricted to human beings. And so fundamental rights demands that businesses take care to avoid upsetting deep-seated entitlements. We're talking about entitlements here, right? If you have a right, you have an entitlement to have your right recognized to the extent that it should be recognized, to a reasonable extent. However, rights often conflict. So your right to property, your right to keep me off your beach, basically is something that you would have in terms of if you put up a sign saying no trespassing, you have a right to keep me off your beach if you own the property, because you have a property right on that. My right to speak freely if I'm out in the public, in a public place, is I can speak freely. And the only time that would be restricted is perhaps if there were some sort of speech that was scheduled. Somebody had been given a right by the city to make a speech, and perhaps the city might be able to enforce a right that the crowd be polite and not interfere with the speech. Although I've been in speeches like that where the crowd was not behaving, which is rather disappointing for a person who wants to come and hear the speech. And so I'm all for some limitations on speeches that are reasonable. So I think that's what our law provides for. It provides we have rights, but there is a reasonable application of those rights, and there can be limitations on them. It's not the Wild West, where the person with the loudest voice gets heard. Kant's, now, so we talk about rights, and like I said, it's a duty-based kind of ethic. So it creates a duty. Kant's rational ethical system is special, and that is very complicated. It invokes respect for personal autonomy of individuals captured by a commitment to treat people as ends and not as means to an end. So under Kant, we are to respect people's autonomy, respect their rights, therefore, right? But also respect their autonomy as human beings. And this is more, like I said, some of the framers maybe were having that Roman kind of ideal that rights flowed from reasonableness. Being reasonable, people would have certain rights. Kant's categorical imperative demands that we acts to be judged by whether or not the actor would want the act to be a universal law for all people. Now, if you think about that, what does that mean? I think it is actually an equivalent way to saying the golden rule. Do unto others as you would have them do unto you. So if you want to have your acts judged by as something, if you want your acts to be something that you're okay with being applied against you, then you're talking about the golden rule, doing unto others as you would have them do unto you. So if you believe that a person has a right to beg for food, okay, is that what you would want done for you? If you were hungry and needed food, would you want a right to go and ask people for charity like that? And under what circumstances would that be maybe limited, if it were limited? So I think that's the duty ethics that I find in that. So I think our time is up, so I'm not going to give you, I have 5 practice questions to give you, and you'll see them on the PowerPoints. Thank you very much.